Welcome back. You're watching Deal Makers, and we are in discussion with Cyril Shroff, Anil Singhvi, and Sunil Sanghai. And let's start with Mr. Shroff. Then we were discussing about the minority shareholders and the kind of voice they have right now. Do you think that regulators have put in enough effort in the past few months and years to give more teeth to these minority shareholders? Have we reached the international standards, or is there a long way to go?
I don't want to compare international standards with us, but at this point, the number of developments which have significantly empowered minority shareholders. Just to name a few, firstly, as far as SEBI is concerned, they've come up with some new circulars. They're coming up with a corporate governance code as well, which postulates that on a number of items where there could be a perceived conflict with the majority, that there has to be a separate consent obtained from the minority shareholders on the basis of a majority of the minority.
Yes.
So the concept of a conflict of interest at the shareholder level is itself becoming a part of the code, and I think that gives a minority shareholder, as in basically a non-promoter shareholder, a significant say in the outcome of certain types of decisions. So that's number one. There are very similar themes in the New Companies Act. Unfortunately, not all of it has been made effective. Some has and some hasn't, and at this point, with the sort of political uncertainty, I don't even know what form the Companies Act finally comes through. That being said, the theme of minority protection is a very big one under the new act, both from a corporate governance point of view as well as any kind of corporate transactions, restructuring, related party transactions, where the minority has been given this similar say through the majority of minority construct.
Right. While minority protection is getting a big leg up, for a deal maker like yourself, Mr. Sanghai, is it making things more difficult when it comes to MNCs really trying to do anything with their Indian arm in India?
So in some respect, it is really good. Because if you look at, in addition to the examples you heard from Cyril, for things like royalty payment, right? So it has to go to the majority of the minority. So it is good from the minority shareholders' perspective. We have seen the royalty going up significantly, though I believe still it is the dividend is significantly higher than the royalty payment. But for some corporate action, if every time if you have a majority of minority, then I'm not sure the right outcome will be achieved.
Dividend versus royalty, that has been a matter of debate for a very long time. Incestuous relationship between the Indian arm and the MNC parent. Do you agree with that, Mr. Singhvi?
Completely. And I want to just correct what Sunil said, that royalty payment is still not subject matter of majority of minority. We are hoping and expecting that that should be also covered under related party transaction, and it should be. So as of now, it is not. But taking a point which he also mentioned about royalty versus dividend, and we have analyzed last 3 years data of about 30 companies, top corporates in India. Okay, if you look at royalty, there's 5 times of dividend. And so much so in case of Suzuki, half of their total net profit, okay, is only going from royalty from India. Half of their global profits are only on account of royalty from India. And they've increased from 2% to 5%. It's not only that, one more point which is there on the royalty, that we have seen even those companies which according to me should not be paying royalty at all, like the company which I worked for in Ambuja Cement's case. Okay, there is no brand which is being used, there is no technology which is being used, there is nothing which is there from Holcim, and yet they want to charge 1%. So there are issues attached to it, and we have seen that many geographies, these same MNCs don't charge royalty. So what is so unique about India that they want to charge royalty?
Mr. Shroff, here can the legal angle be explored? Do we still see a lot of loopholes? Because royalty either has to be probably as a reward to the parent company, be linked to the reward as dividends to the minority shareholders, or at least be correlated with the kind of top line, bottom line performance that they are showing in the Indian market. Can that area be explored? Has it come up for discussion? Is anything being done on that?
No, if you look at it in the broader context of are these related party contracts, in as much as one's control over the company is being effectively used for compensating oneself through royalty, I think you open up the debate in terms of whether the terms are fair and whether you need a majority of minority view. So it's a question of where do you want to draw the line in terms of what types of contracts should get minority consent as well, because there's a conflict. So it's really an extension of the conflict of interest rule. But I just want to come back to something which Sunil had said a few moments ago in terms of court schemes. I think the Companies Act is also a bit schizophrenic. So on the one hand, there is a lot of movement towards majority or minority. But on the other hand, there's something completely different in as much as for a right to object in the court, the threshold has been raised to 10%, which basically means no minority can effectively object to a scheme of restructuring. So what is the legislature really trying to tell you? Are they, it's completely difficult to sort of reconcile both these views. On the one hand, it's extremely pro-minority. On the other hand, the minority's voice has all but been taken away in certain types of situations. So there's no consistency, I think.
Mr. Shroff, I wanted to bring up one point. I have seen in 2 cases that an internationally listed company, the shareholders, the institutional shareholders in that, and some of them common in India, they both, I mean, isn't there a conflict of interest? And that is one loophole that a lot of these shareholders have used up, because ultimately if the parent company is benefiting from a scheme of arrangement in India, he may not be in favor of talking about the Indian shareholders, but will get benefited from the international parent company.
But the kind of institutional shareholders whom you're talking about, who sort of participate in both of them, the actual decision making happens at different levels and different segments of the firm. So it's not the same individual or the asset manager who's deciding on what policy to pursue at the parent level and what to pursue at these levels. So the actual decision making, I think, operates in silos.
I beg to differ, particularly on this case, because we have learned from large institutional shareholders since we interact with them that as far as voting is concerned, it's centralized. It's not a fund manager's domain to say whether I want to vote in favor or not. There is a centralized which looks at global situation and then they vote on that.
I think it's very fact specific, because if it depends on how material the Indian business is in the size of the overall.
And that of course will hold.
I can give you a live example in that, because if you have a multinational and they do a corporate action in India, and they have shareholders which are common, the common to the parent and the common to the Indian subsidiary, obviously, and I've interacted with them, I've seen their ability to really distinguish the two is there, and then they take the decision based on the reality of the market. So for example, if the Indian market is trading at twice the multiple of where the parent is trading, and if there is a open offer which is at the premium of where the market is trading, they definitely understand that yes, that premium is required to be paid, and that's the value of the market. So they clearly appreciate that. So while the decision in some sense from the investment point of view, there are silos that do different fund manager, they really look at it, but they also really appreciate what is required, what are the dynamics of the 2 different markets.
We were on voting, Sunil, sorry for again putting it. As far as selling the share, profiting and all that is a fund manager's domain. Voting is no more a fund manager's domain. You look at most investors globally, and since we approach for our dal roti, we know it reasonably well that where the key lies in terms of who's going to be deciding on that.
Take that as one of the last comments on this discussion, but I will continue this discussion and come back with some of the structures that we have seen, and are there more loopholes in the system which could be plugged, and also will take the final comments on this hot topic, but stay tuned with us.